Alternatives to foreclosure and bankruptcy. Number 1, the bank and the borrower rent out the property.
We did another property that was in foreclosure where the bank became the landlord. Well, that's not quite right. The person who borrowed the money still owns the house. They rented it out. It was in the high rent district in West Bloomfield. The tenant was paying $3,600 a month in rent. 100% of the rent is going to the lender. And the lender has got a local real estate broker that's managing the property, taking a little $150 a month management fee. And all of that $3,600 is going to the principal and interest that the borrower has. And they lowered the interest rate on the note too. They lowered that down to 5%. So the idea from the bank's perspective is we're all in this boat together. So the bank did not want to foreclose and put another piece of real estate on its books. This enabled the borrower to get something close to a fresh start, and as long as that tenant takes care of the property and pays the rent and maybe stays there for 4 or 5 years, the lender and the bank can both get caught up on this scenario because of the downturn in the economy. Now, if that tenant does not honor their obligations under the lease, the bank is going to have to do not only an eviction, but also a foreclosure. But the point is, you can kind of look at it from the bank's perspective and say, what's necessary to make this work? And they considered allowing the person to rent it, lowering the interest rate, rather than just have foreclose and do another one on their property.
Number 2, deed in lieu of foreclosure.
Now, there's something else that can happen. For us, from a borrower's perspective, it's called a deed in lieu of foreclosure. The word in lieu, I guess, is probably just like a legalese kind of thing. It would just be a deed instead of foreclosure. So a deed in lieu of foreclosure would be somewhere here before the foreclosure sale. The borrower contacts the lender, acknowledges they're not going to be able to keep the house, can't afford it anymore. So they then give the bank a deed back to the property. The bank now does not have to go through this foreclosure process. Now, I put it here rather than here for a reason, and we'll distinguish that in a second. The bank now doesn't have to hire the attorneys, publish in the newspaper. The property is simply returned to them, and the homeowner who's losing it moves out. That's a deed instead of foreclosure. But there has to be some back and forth on this, because by law in every state, the person has a right to be foreclosed upon and try and save their house. So the borrower is giving up their rights, their time. Get to live there for 6 months without paying the taxes and the water and etc. But what would the bank be giving up? What's that? Interest, attorney's fees. Keep going. What else?
The ability to sell it for more than what is owed.
No, actually, the bank would be getting that. Think about it, because if the person says, here's the deed in lieu of foreclosure, here's the keys, I'm sorry it didn't work out, don't loan me money anymore, and the bank is done with it and they turn around and list it and they can sell the $60,000 house for more, the bank gets to enjoy that profit. The bank is giving up the right to go after the person for the money.
Yes, because usually the lien or whatever, the mortgage is free and it's taken care of, period, that's it.
It's sort of a wash. Don't bother foreclosing, I'll move out, I'll keep it vacuumed and clean. Give me a clean bill of health. So that's not a taxable event either. Why would that not be a taxable event? Here the person owes $60,000. They give a deed in lieu of foreclosure. The bank then considers the note paid in full.
Because you don't know what the house is going to go for.
because you don't know ultimately what the bank could sell the house for more than 60 or less than 60. But also, the note has been satisfied not by cash, but by real estate. So it's not a taxable event, where a short sale would be. If I owed you $100,000, and rather than give you cash, I give you the deed to a condo I own somewhere, and you determine the value was $100,000, that will be a fair exchange.
Number 3, negotiate a settlement with the bank.
Now, one of the things that I've seen happen is a little different is banks sometimes are not even foreclosing. They've become very cooperative. We did one transaction where the person fell behind, got back up on their feet, and wanted to keep the property. They were behind about 6 or 7 payments, but they only had about 4 payments to make up to reinstate the loan. So what we agreed to, we sued the person. Rather than foreclose, we just sued them. There's a promissory note. They signed the promissory note. We're suing on the promissory note. We then entered into a settlement agreement where the person agreed they owed the money. We had a judgment for that amount of money. Well, actually, it was a settlement agreement, not a judgment. We had a settlement agreement that they acknowledged owing that amount of money. They made the 4 missing payments and then gave a deed to the bank for it to be held in escrow so that they could now continue to reside in the property. And if they fell behind again more than 45 days, the bank could then record the deed and simply evict the person. So with cooperation between the bank and the borrower, they were able to resolve the situation. Okay? Now that cannot be done outside of a court order, because you have to worry about the person. They have certain rights in the property. They have the right to foreclose. They have the right to be foreclosed upon, which is notice, time period to redeem, etc. So in exchange for their giving up those rights, the bank waived the acceleration clause, and also the bank reduced the debt by $10,000.
Bankruptcy.
There's 3 types of bankruptcies: Chapter 7, 11, and 13. Upon filing of it, all collection activity stops.
So it doesn't even have to be approved.
It's filed.
Okay.
Now, an individual creditor can go to the bankruptcy court and ask to proceed. Judge, this person filed bankruptcy. There's a stay of proceedings. On this particular matter, I wish to proceed. And the judge will conduct a hearing if it's contested and may say, I'm lifting the stay as to this creditor, so you two go have at it. Okay. Now, what actually happens when a person declares bankruptcy, they no longer own their stuff. When a person files bankruptcy, the bankruptcy court appoints a trustee. And that doesn't matter if it's a Chapter 13 or a Chapter 7. In a Chapter 11 bankruptcy, very often the debtor is the trustee. We call it debtor in possession. Now, the minute you file bankruptcy, you no longer own your stuff. Who does own it? The trustee. And the trustee's job is to take a look at what the person owns, what their obligations are, and you're given certain exclusions. You have a certain percentage of equity in your house. There's something called a wild card exemption where you can put various sums of money here and there. You get a little exemption for some small equity in your car. So there's some various exemptions, and I'm not going to go into any of the specifics of them. Bankruptcy stops an event. It stops people from doing stuff. You can't pursue this lawsuit. You can't conduct the foreclosure sale. It doesn't stop the running of the clock. Timeline for foreclosure. Bankruptcy stops foreclosure activity. It doesn't stop the running of the clock.